I think we should slowly start. Try to screen as well. So hello everyone, my name is Julija Sardelic, and I'll be the chair of the Discussant, as it was initially announced. I'll be the chair of this very interesting panel that is entitled Crisis in Human Rights Protection of Migrant and Minority Groups. Very happy to be chairing today. And we have three very interesting presentations ahead. So first, it will be Hellen Carvalho from the ILHRU Center for Human Rights, National University of Ireland, Galway, and her very topic presentation entitled Possible Solutions for the Refugee Crisis, the Right to Return and the Right to Remain. Hellen, please, the word is yours. You have 15 minutes. I'll board you.
I would like to thank the conference's organization for the opportunity, my colleagues that came here today to listen and discuss this panel's project, and our chair, Julija from the University of Liverpool. The title of my research is Possible Solutions for the Refugee Crisis, the Right to Return and the Right to Remain. Before getting in my research per se, I would like to clarify that by discussing the right to return and the right to remain, I don't intend to undermine the right to seek asylum. I am aware that under certain circumstances, fleeing is the only option. In this case, there is no other possible solutions out there. So the right to return and the right to remain are not competing ideas to the right to seek asylum. They are possible and long-term solutions for the refugee crisis. So in light of this consideration, my presentation will be divided into two parts. First, I will address the right to return, understood here as the precondition to voluntary repatriation. And second, I will discuss the right to remain, which is closely linked with the right not to be displaced and other several fundamental rights. In this context, I will also address two other concepts, the human security paradigm and the responsibility to protect. Finally, I'll present some concluding remarks. So regarding the right to return, it means that a person shall physically move back, or that a person can physically move back to its country of origin and enjoy the country's assured right upon return. It is implied in Article 9 and expressly recognized in Article 13, Paragraph 2 of the Universal Declaration of Human Rights. It is also present in many UN and regional documents, such as the ICCPR, the Convention on the Elimination of All Forms of Racial Discrimination, the European and the American Convention on Human Rights, and the African Charter. The first difficulty within this right, though, is the implementation of it. Because while the UDHR and the ICCPR do not specify the link of nationality in the right to return, possibly considered nationals and residents of the state, the European and the American Convention expressly limit this right for people that are nationals of a particular state. However, people do not necessarily link their identity to their place of origin. With the current intense movement of people all over the globe, the concept of home is becoming more complex and dynamic, raising questions such as, is home where one was born, used to live, where one's relatives live or lived, or anywhere one can make a decent living? To elucidate this matter, the UN Human Rights Committee, in its General Comment 27, found that the term country of his nationality from Article 12.4 of the ICCPR should not be limited to the nationality in a formal sense. It embraces the individual who, because of his or her special ties to a given country, cannot be considered a mere alien. So moving forward, according to Vincent Chattal, voluntary repatriation is what allows refugees to exercise their human right to return. This concept is one of the three durable solutions for the refugee crisis, and it was recognized by the UN as the most desirable one. The only provision that transversely deals with voluntary repatriation, by making it clear that the refugee status is a transitory condition, is Article 1C4 of the 1951 Refugee Convention. However, under this document, the notion of voluntary repatriation represents a policy recommendation more than a legal obligation. A policy recommendation and not a legal obligation at all. So thus, to fill in or trying to fill in this legal gap, the UN has established some guidance in several resolutions, such as that countries of origin, countries of asylum, the UNHCR, and the international community should do everything as possible to enable refugees to exercise their right to return in safety and dignity. Safety means that the return has to take place under conditions of physical and material security. And the term dignity means that the returnees are not to be mistreated. When Cambodia started a massive repatriation operation in 1993, it had to conceive a long and a short-term perspective of relief and development. While we may have been a model of management, we also exposed many dilemmas inherent to this type of process. One of them was if the ones returning had full knowledge of the environment they would find upon return, and if their return was indeed voluntary. So the changing circumstances and the voluntariness are the cornerstone of international protection regarding the return of refugees. In this regard, the UNHCR Executive Committee set up in its conclusion 18 that governments of countries of origin have to provide formal guarantees for the safety of returning refugees. And in its conclusion 40, emphasized that the repatriation should only take place at their freely expressed wish, and that it has to be carried out under conditions of absolute safety. The changing circumstances cannot be merely transitory. It has to amount to fundamental changes. And the voluntariness derives from the idea that the involuntary return of refugee is prohibited under the principle of non-refoulement. Sorry for my French. In conclusion, if the conditions in the country of origin have changed significantly, and if there is voluntariness from refugee, the right to return to one's country, carried out through voluntary repatriation, has great potential to offer people the opportunity to go back to a place that they can call home. Okay, now as to the right to now, as to the right to remain, according to James Hathaway, the best solution for the refugee problem is obviously to eradicate the harms that produce the need to escape. This right is about not having to become a refugee, not having to flee, not being displaced by force or what, together with the feeling of security that comes with being protected or feeling protected. It involves the state's responsibility in guaranteeing broader social, cultural, and political rights as part of community building, stability, and development. One concrete example of state's responsibility over its population can be found in the ICJ Not-a-Bomb case, which defined nationality as a legal bond having as its basis a social fact of attachment, a genuine connection of existence, interests, and sentiments, together with the existence of reciprocal rights and duties. So the right to remain is also closely related to the right not to be displaced, which entails the prevention of forcible or involuntary movement of people. This protection can be inferred, a contrario, from the freedom of movement and choice of residence recognized as a human right in Article 13.1 of the UDHR and 12.1 of the ICCPR. Furthermore, states are also obliged to take all the necessary legal measures to give effect to rights such as the right to an adequate standard of living, including housing, established in Article 11.1 of the ICESCR. As established by the Committee on Economic, Social, and Cultural Rights in its General Comment 4, this right is equivalent to a right to live somewhere in security, peace, and dignity. Although it's very hard to determine what would make people not leave their country of residence, considering that, especially in unequal societies where conflicts are most likely to happen, the reasons to leave for one could be quite different than the motives of others. But in the former Yugoslavia context in 1992, the UN Special Rapporteur declared that in that specific example, the decision to flee had to do with security and basic necessities of life, or the lack of basic necessities of life. The reality is that the massive displacement of people show that some states are not complying to their basic responsibility towards their citizens, leaving people with the only solution of fleeing and searching for asylum or seeking for asylum. In order to shed some light on states' responsibility and in the international responsibility, I will elucidate two concepts very quickly: the human security paradigm and the responsibility to protect. So the human security paradigm questions the notion of security that has been established up to this day. So elements such as territorial sovereignty, national interests, and military forces no longer fit in nowadays conflicts. So for this, the human security paradigm is considered one of the most important efforts to humanize the security discourse. The UNDP and the UN Commission on Human Security consider that the concept of human security should include threats such as hunger, disease, repression, and disruption in the patterns of daily life. It should also protect vital freedoms, allowing people to take charge of their own lives. So if the most likely environments to host violent conflicts are and consequently expel people from their territory are usually characterized by the lack of democratic institutions and the rule of law, or economic failure, among others. The importance of this concept is based on the fact that if the factors causing human insecurity are eliminated or controlled within a state, there is a greater chance that people will choose not to flee. The responsibility to protect is a concept that attempts to establish a collective responsibility to guarantee the protection of population. This responsibility resides first and foremost within the state and residually with the international community. It aims to prevent violence through the development of assistance programs to help states build inclusive and resilient societies in order to ensure that groups are not excluded and state institutions are robust enough to withstand political crisis. Some of the practical measures that state and the international community should seek in order to protect its people is to sign and respect human rights treaties, carry on conflict-sensitive development analysis, and advocate for local dispute resolution capacity. I acknowledge that the responsibility to protect has been used as a coercive tool to enforce sanctions and military actions. This was the case of Libya in 2011. Since then, the international community, especially China and Russia, became very skeptical about the responsibility to protect concept. Nevertheless, although the Libyan experience and the UN Security Council's non-intervention in Syria have somehow discredited the responsibility to protect concept, I defend that this doctrine is still a relevant preventive tool on assuring that states abide by their responsibilities towards their citizens. So if public policies and development actions are systematically made available, a construction-making process that might be able to transform a society from one that resorts to violence to under-resort to political means to resolve conflict. And this might influence on people's decision not to flee. Moving to my final considerations, from what I've researched so far, I understand that conflicts will undeniably continue to exist. Most likely, the phenomenon of conflict will persist to grow. However, this research, yet in progress, intends to demonstrate that the more different actors work preventively to identify the root causes of conflict and to remove the harms that produce the need to escape, the more we'll see resilient societies that are able to go through and to overcome crisis and conflict. In other words, societies that absorb shock and continue to function. If individuals and communities are able to enjoy certain rights, civil, political, economic, social, and cultural rights, the need to flee might not be as wide as it is today. And finally, it is evident that the right to return and the right to remain are still long-term goals, and if they come to the realization of them, they will not be upon us half for all. However, what this research insistently try to demonstrate is that the search for solutions that grant people the opportunity to be in a place that they culturally belong should be imperative. Thank you.
Thank you very much, Hellen. Thank you very much. This was really a good timekeeping, and I already have a lot of questions for you. But first, we'll continue with another presentation by our next speaker, Hudson from the University of Bristol, and the title of his presentation is Human Rights Protection and Internally Displaced Persons, the Place of the United Nations Guiding Principles in the Development of an IDP, Rights to Return. Ben, the floor is yours, 15 minutes as well.
I'm kind of hoping I don't need the microphone. Okay, yeah, all right, great. Thank you very much, everybody. Thank you for the conference organisers for having me here today. And thank you also for putting together such a coherent panel. Thank you to Ellen, because you've covered many things that hopefully now I can skip relatively quickly over. But obviously, as is the case with most migration research, we fundamentally differ in that refugees and IDPs are very different contexts. So I'm from the University of Bristol, and I'm in the second year of my PhD, all about IDPs, human rights protection, and the UN guiding principles in particular. So, as most good law presentations do, I will begin with the definition. Just to state, and I love definitions like that, particularly important, especially in the IDP context. The definition I'll be using for internally displaced persons comes from the 1998 UN guiding principles. Introductory paragraph 2 states that IDPs are persons or groups of persons who have been forced or obliged to flee their homes or basic residence, in particular as a result of those 4 reasons: armed conflict, situations of generalized violence, violation of human rights, or natural or human-made disasters, and who have importantly not crossed an internationally recognized state border. To compare, definition 2, with the Refugee Convention, there are a number of important differences. The one that people often refer to is obviously the internationally recognized state border, and that refugees have crossed an internationally recognized state border, but importantly, there are a number of other key differences. For example, with IDPs, in particular, has been clearly stated to be a non-exhaustive list of reasons for displacement of causes, which is in contrast to the relatively restrictively interpreted refugee causes, and also the well-founded fear of persecution is not present in the IDP definition. So I want to bear those in mind as we move forward. Just as a little bit of context, if you aren't aware of the IDP situation, it has been recognized sort of since the end of the last century that it's one of the most tragic phenomena of the contemporary world. So I'm relatively up to date, although some recent reports came out recently, so I will update soon. Some key figures. Displaced by conflict alone, as of January 2014, was 33.3 million people. As you can see, in comparison to refugees, significantly higher and really now on the point of double the number of refugees. And with 77% of all IDPs being in 10 countries, it probably won't surprise you to see Syria there, or Iraq, or Sudan. But not only what we see as more recent conflicts or displacement situations, but also those that have been are established and have been going for some time, so protracted situations such as in Colombia, which has hosted a huge amount of displaced persons for around 40 years. 2014 was the highest single year increase that has ever been recorded in regards to the number of internally displaced persons, 38 million as a result of conflict, and 19.3 million as a result of human or natural disasters. Highlighting this figure is important, but something else I want to show, and thanks to the Internal Displacement Monitoring Centre, because they make these amazing maps and figures I don't know how to create myself. It's a widespread issue. It's not just these 10 countries that we're thinking that we often hear about. And although the numbers may not be as large in some states, for example, in places like Georgia, where I used to work, or in Cyprus, I think Cyprus now, it's almost a fifth of the population are in some way associated with internal displacement, and Georgia a similar number. So even if the numbers may not be as high, within 200 to 250,000 IDPs in the state, the effect is still profound. So it has been recognised since 1998, or the early 1990s, to be more accurate, that internally displaced persons, as a result of their displacement, face a number of human rights violations, or are unable to enjoy their human rights directly as a direct result of their displacement. And this could be as a result of a direct violation, so an intentional violation by the state or by other parties, or it could be as a result of legal processes or the law itself not effectively taking into consideration the internal displacement context. For example, many young people are unable to enjoy their right to education, often because they don't have a letter from their previous headmaster saying they wish to change school, for example, and they should definitely not be expected to return to collect said letter. But there are many violations of human rights as recognised in the Guiding Principles, which I'll come to. But one in particular is the freedom of movement, which my colleague Hellen has nicely already introduced. So freedom of movement, International Convention on Political Rights, Article 12.1, everyone lawfully within the territory of the state shall, within that territory, have the right to liberty of movement and freedom to choose its residents. Helen's already touched on some of these, some of the key points I want to really bring out. Well, what does this tell us about the right to freedom of movement? Well, there's voluntariness and safety, and absolute safety, I like that, we use that in the future, and with dignity. Importantly, in regards to IDP situations, that this freedom of movement applies to the whole territory of a state, as has been confirmed by the Human Rights Committee in General Comment number 27. And there must be, it must be sustainable, and there must be some degree of permanence, which I think is revealed by the joining together of not only the right to liberty of movement, but freedom to choose his or her residence. Subject to some restrictions, but only as those are outlined in accordance with the law and so on. So how explicitly or how clearly is freedom of movement linked to internal displacement and to the right to return? Well, IDPs as human beings have the right to freedom of movement. However, there is a violation of their freedom of movement, and it's concomitant with internal displacement. As I've mentioned, it applies importantly to the entire territory of the state, and IDPs are not able to return to a particular part of that state, and as a direct result, they do not enjoy their freedom of movement. Unlike many, I would not say all, but like many within their fellow members within their state. So IDPs do not, by the very virtue of being IDPs, enjoy their right to freedom of movement. The fact that IDPs do not enjoy their freedom of movement and that they have this right to return has been increasingly recognised in numerous international, largely political bodies, often in regards to countries, states such as Georgia, Azerbaijan. So we have UN Security Council stating that IDPs have a right to return to their homes in secure and dignified conditions. Azerbaijan, an inalienable right, as being mentioned by the UN General Assembly, and we've also seen a right to return mentioned in a number of peace agreements. for example, the Dayton Agreement, all refugees and displaced persons have the right to return to their homes of origin. But my starting point of my research from the very beginning has been what is the legal basis for this. These very high-level proclamations of a right to return for IDPs, which are often only in relation to a very specific context and often only in relation to a very specific type of displacement, conflict-induced, protracted situations. So, the legal basis for an IDP right to return, well, again, thank you, Hellen, I don't need to go too much into a right to return generally, but just to lead on from what you said about the Universal Declaration on Human Rights, international law, especially international human rights law, recognizes as fundamental the right to return to one's own country, whether this be the right to return or an associated right to enter. It's right to enter in the ICCPR, the Human Rights Committee says that involves a right to return. And here we see right to return explicitly mentioned in the International Covenant on the Elimination of All Forms of Race Discrimination. Unlike Article 12.3, 12.1, we don't see the same limitations as we do. So ICCPR Article 12.4, right to return, is not subject to the restrictions under ICCPR Article 12.3. And in fact, Human Rights Committee said it can think of very few reasons as to why it would ever be justifiable to prevent somebody from returning back to their own country. Probably we should tell Theresa May about this. The importance of ICCPR Article 12.4, the right to return to one's own country or to enter one's own country, has also been recognised, again, as Hellen pointed out, in regards to refugee returns, because the Refugee Convention does not tell us much about this. So ICCPR Article 12.4, right to return, is particularly important. But, as I'm sure you're probably all aware, this right to return self-evidently does not apply to internally no explicit applicable provision for IDPs. And the way I see international human rights law treatment of displacement is that while there is a recognition of a special relationship between an individual and their home country, as broadly defined as the Human Rights Committee, there is no special relationship recognized between a person and a particular part of his or her country. And therefore, we see no recognition or protection of an equivalent internal right to return. In fact, in international human rights law is particularly helpful. We only see two explicit references to a right to return that is applicable to IDPs, and these are outside of international human rights law. First of all, we have the International Labour Organization's 1989 Convention on Indigenous and Tribal Peoples, Article 16.3, and we also have the International Committee for the Red Cross's 2005 Customary International Humanitarian Law, Rule 132, which both reference explicitly a right to return that is explicitly recognized as being applicable in situations of internal displacement. Great. However, both of these provisions, while they do apply, are still both inherently limited when we view them through the lens of internal displacement. I look at these limitations in two ways. Firstly, both provisions are limited to only some situations of internal displacement. So in ILO Convention 169, we see following relocation. Now, relocation of individuals, for example, in situations of dam building or development projects, is a key area and is a key cause of internal displacement, but it is only one narrow part as we reflect back on the original definition. The same with ICRC the Rule 132, we saw this earlier this morning when we're talking about armed conflicts. International or non-international armed conflicts have to reach a certain level of intensity, a threshold. And from the very beginning, research into internal displacement situations has shown that individuals are more often than not internally displaced as a result of generalized violence, as we saw in the definition, which would not fall within international humanitarian law. Secondly, and partly as a result of the first, both provisions are limited to only some IDPs. It's probably quite obvious, and ILO Convention 169 only relates to indigenous and tribal peoples. And it's quite obvious that in regards to international humanitarian law, it would only apply to those who were affected by an armed conflict or non-international armed conflict as recognized under international humanitarian law. But also, important principles, such as the principle of distinction within IHL, is not something that is recognized within the IDP framework, being a human rights framework. Therefore, there's no restriction on rights based on your role within a conflict. So here are some of the limitations that we find. Now, we could get rid of these and we could bypass some of these limitations. The issue is, as we've already seen, international human rights law, but we might be able to bypass them, does not provide the provisions that we seek. Now, this was recognized in 1996 in the UN Compilation Analysis of Legal Norms. It recognized that while there are general norms, the freedom of movement, as was mentioned earlier, in regards to a right to return, there is no explicit provision in international human rights law, and that this gap needed to be filled by an appropriate international framework on internal displacement. Both in the guiding principles, a human rights base, as I mentioned, normative framework provides minimum standards for the protection of IDPs. It has been viewed since its inception as the most authoritative statement of the rights of IDPs. Soft law, hard law, politically, a very soft instrument. There's been many ways of describing it. But one thing I'd like to say is that it is largely a restatement of existing international legal provisions, and it has been recognized in huge international fora. For example, the World Summit in 2005 unanimously recognized its importance. It contains those principles, rights and obligations, but what does it say about freedom of movement, and what does it say about right to return? Specifically, do the guiding principles include an explicit, comprehensive legal right to return applicable to IDPs? Well, we see principle 14, and everything is based on the right to movement, and so on. Very similar wording, slightly different, but very similar wording to ICCPR, Article 12.1. We see protections against forcible return, extremely important, so the IDP should not be forced to return back, similar to non-refoulement within refugee law. And as I mentioned earlier about getting the certificate from the headmaster, IDPs should not be required to return in order to enjoy certain rights. But when it comes to actually providing a right of return for IDPs, we see a shift at the very end of the document, the very end of the guiding principles, away from right speech in regards to the responsibilities of competent authorities. Now, I'm not saying that Principle 28.1, which says that competent authorities have a duty to establish conditions that allow IDPs to return, is not welcome to see. But the issue is that there is still no explicit recognition here that IDPs have a right to return under international frameworks, in this case, a non-binding framework. So what does this tell us? Well, it tells us that there remains a clear hesitation within not only international law, but also within international non-legally binding frameworks of asserting IDP freedom of movement and return. And that the guiding principles as a non-binding legal instrument, could have done something, especially based on the previous recommendations given by the compilation analysis of norms, to include this aspiration. But this is still missing from the frameworks. And this has profound consequences for the protection of IDPs and their movement-related needs. The right to return is a concrete basis, is not only elusive still in international law, but also in non-binding frameworks, as I mentioned. Such an omission leaves IDPs without effective recourse to a right to return that they can use to challenge their displacement. And further, the situation sustains an increasingly unjustifiable gulf in the protection between those subject to involuntary movement who have crossed an internationally recognized state border, refugees, and those who have not, IDPs. Now, I thought this would happen, so I'm going to have to finish there. But I have a series of challenges which I would love to discuss with everybody over wine later. So I will get Patrick to print this out and we can take it to dinner. So thank you very much for your attention.
Sorry about it, we had to put you short. But we have a lot more interesting presentation today, and then we can maybe discuss some of the things that you have on your last slide. So the last presenter is Stefano Angeleri, also from Irish Center for Human Rights, National University of Ireland, Galway. And the title of his presentation is The Impact of the Economic Crisis on the Right to Health of Migrants as reflected in the jurisprudence of the UN Committee on Economic, Social and Cultural Rights Monitoring Activity. But please, Stefano, the word is yours.
Thank you very much. Thank you very much, and thank you very much for the attendees and the organizing committee for this opportunity. This was the original title of my presentation. It has slightly changed, but still I started from the impact of the economic crisis on right to health of undocumented migrants. So when I first sent the call of this conference, world crisis, in my mind, I mean, I immediately linked that to the economic crisis and budget constraints on the accessibility of the right to health for this particularly vulnerable group of migrants. Actually, the more I enter in depth into the analysis, I could realize that actually this discourse of crisis impact actually hides other important crises, structural crisis for undocumented people. Well, one is, I mean, it's not only in relation to undocumented people, but it's the structural crisis of implementation of socio-economic rights on the ground and in domestic legal orders. And second, the structural difficulty of undocumented migrants to assess human rights protection. So the scope and the purpose of this paper is really narrow, actually, because it tries to assess the impact of the economic crisis on the right to healthcare of undocumented migrants within the jurisprudence of the Committee on Economic, Social and Cultural Rights. When I say jurisprudence, I don't really like it because in Italian jurisprudence is more case. But I have analyzed the 44 reporting cycles documents of the last 8 years within the context of the monitoring procedure concerning European countries, a sort of broad geographical Europe, more or less the one of the Council of Europe, excluding Turkey and including Belarus. So geographically, the scope is this. The context is this UN committee jurisprudence. The target people are just vulnerable groups, and the subject, I mean, the substantive right is the right to healthcare, and of course the impact factor is the crisis. So I just want to spend a few minutes on preliminary remarks to understand this paper and this research. So first of all, why the Committee on Economic, Social and Cultural Rights? First, the Committee on Economic, Social and Cultural Rights, as you all know, is the monitoring body of the ICSCR, and it has different competencies, and I focus on monitoring. On monitoring, because the monitoring procedure, so this dialogue in which the committee can stay engaged on a periodic basis, is the only one compulsory accountability mechanism open to, I mean, in the field of socioeconomic rights internationally speaking, at UN level. It's an independent periodic review, and it's also very suitable for the analysis of undocumented migrants' rights because it doesn't need an activating application. I mean, to start this. I mean, we don't need undocumented migrants to vindicate their rights in a court or in a quasi-judicial body, but they can be replaced easily by the shared reports of NGOs that are particularly active in defending undocumented people rights and social rights as well. Of course, the committee and these monitoring procedure, I mean, they have a lot of shortcomings. We're talking about, I mean, the final decision are recommendations, so a really weak legal power, legal effect, sorry. But still, I mean, at the very end, I will spend a few words on this. So the right to health, is the right to the highest attainable standard of health. So it's not the right to health, to be healthy, first of all, and it's a social right. And as we have heard this morning, its qualification as social right, I mean, it means that conceptually speaking, it has encountered a lot of opposition in Western countries, Western democracies, and in many constitutions of the European countries, this is not considered a legally enforceable right, but a guiding principle of social policies of programmatic nature. And so, once again, this discrimination between different generations of rights. As socioeconomic right is the right to health must be realized by the state progressively, but there are a few provisions like the principle of non-discrimination and minimum core obligation, minimum core rights that they're, I mean, they escape from this to a certain extent from this progressive realization. Article 12 of the ICSCR says that stipulates that everyone has the right to high-sustainable standard of health. This is first of all. So everyone, this should include undocumented migrants. So who are undocumented migrants? Undocumented migrants have I mean, they don't, I mean, I can provide a definition, but they don't, I mean, we don't have a definition in any legally binding instrument. And undocumented people are those people that don't comply with immigration law requirement. So they asylum seeker, people that fall back in a situation of irregularity because their residence permit hasn't been renewed, or I mean, enter clandestinely country and decided to stay. So a really varied group of people, and they are. We don't have data. I mean, official data. I mean, because of course these people live in shadow. So we have estimates. It should be around in the world around 30 million, but still this is another important shortcoming of the system. I mean, we don't have official data, so we are required to get disaggregated data. Still, when it comes to undocumented migrants, states are particularly reluctant from providing data and to enhance the rights of these particular people. They are reluctant to keep the attention and to setting up instrument for the protection of these people, because undocumented migrants' rights clash really violently with one of the organizing principles of the international law, which is the principle of state sovereignty. The principle of state sovereignty, as all of you know, I mean, includes also the power to control the entrance, the residence, and the expulsion of aliens. And the very presence of undocumented migrants, I mean, it's a breach of state authority. So the result is that states are not willing to engage with this group of people, apart from measures and policy to return them to their countries. So, but not only states, European Union, and did the same recently, and states not only internally, but also engaging with agreement with transit countries. I'm thinking about Libya's agreement that we have in Italy still. So another tool of that states use to curtail the rights of this population is to restrict social entitlement, like the right to health, to make less attractive the destination countries. These, I mean, the clash between sovereignty and undocumented migrants' rights, social rights, I mean, right to health and social rights, and I mean, these are sort of basic concepts in order to that I have. I need to preliminary define to go further in the research. So in relation to the most recurrent concept, legal concept, in the jurisprudence of this committee, the Committee on Economic, Social, and Cultural Rights, in relation to the right to health of undocumented migrants, the most recurrent concepts are the concept of vulnerability, non-discrimination, to a certain extent also minimum core obligation and rights. So I have tried to assess them and to record them in this analysis. First of all, I would like to start with vulnerability. Vulnerability is a mantra for the jurisprudence of this particular committee. So the protection of vulnerable groups, of vulnerable people, even in case of severe resource constraints. Regardless of that, despite that, I mean, the committee hasn't defined what vulnerability means. So if it embraces human vulnerability school or vulnerability group scholarship, and and so, but I mean, there are different international bodies that have engaged with vulnerability of undocumented migrants. But while, for example, in the European context, the European Court of Human Rights, the European Committee on Social Rights, they consider vulnerability of undocumented migrants as one of the elements, I mean, this particular, the absence of status, as one of the elements of their vulnerability. So they needed, for example, a really severe health status to in few decisions to to consider vulnerability as a really important legal concept, or the age. So in the context of the European Committee of Social Rights. For the committee, vulnerability of undocumented migrants because of the lack of legal status, and because, of course, I mean, as a result of that, a socioeconomic vulnerability has been considered a vulnerability per se. So it's enough to qualify that as vulnerable groups. And a second legal concept, which is really important in dealing with undocumented migrants in the social sphere, is the principle of non-discrimination. The principle of non-discrimination is not an absolute principle, as all we know. It can be limited. It can be limited for objective, reasonable, reasons, and only proportionally. But limitation of socioeconomic rights in the context of the ICSCR are possible solely for the purpose of promoting general welfare and in a way compatible with the nature of the covenants. So restricting radically the right to healthcare for undocumented migrants because as an austerity measure, it's probably difficult to defend in the context of, arguing on the principle of proportionality, where there are possible any other less restrictive measures, or the money to fund primary health care, because the minimum essential level of these rights universally should be, according to the jurisprudence of this committee, essential primary health care. While actually most of states, they just provide emergency health care. Non-discrimination and vulnerability, they both compose one of the minimum core obligations in relation to the right to health. So non-discrimination in assessing healthcare for vulnerable groups is, the guarantee of this is a minimum core obligation. So minimum essential level of these rights. This, of course, is, from the analysis of all these continuing observation and the legal order of states, this is not the case. In most of cases, states just guarantee the most urgent treatment for this group. The crisis, what is the impact of the crisis? So the crisis didn't really change international law, at least in its soft law form, because the 2012 statement of the chairman of the committee in relation to the economic adjustment in period of crisis, protect minimum core obligation and vulnerable groups from these measures. What is more concerning is that the narrative of the crisis has been used by states, regardless of their international obligation, as a tool to, as a justification of the radical limitation of the right to health to emergency care. And these actually uncover the evergreen tension of between human rights and sovereign powers, because the right to healthcare, healthcare is mostly provided through public services. And of course, undocumented migrants try to refrain from entering into contact with state authority. And state authorities try to limit to the greatest possible extent the rights of this group. But when you need the services provided from the very state, this is a structural barrier that you encounter. So my concluding remarks. My concluding remarks are that the scholarship both scholarship approaches. I had the time to run through that, to go through that. In the practice of the International Covenant on Economic, Social, and Cultural Rights, support the inclusion of undocumented migrants into a vulnerable, the inclusion as in the category of vulnerable groups. Being a vulnerable people triggers the applicability of all a series of instruments and statements in order to enhance the protection of this group. And both non-discrimination and vulnerabilities are elements of the minimum core obligation. So at least the essential elements of the primary healthcare should be provided according to international law. The problem that I've mainly encountered in dealing with this concluding observation, list of issues, and other statements within the jurisprudence is that to be a real guidance for states to consistently implement their human rights, the committee statement, they lack of consistency in the vocabulary itself. So sometimes they refer to the desired minimum standard as basic healthcare, some other times as necessary healthcare, primary healthcare, and this generates confusion, and also generates confusion to identify which is the desired minimum legal, the minimum binding standard for states implementing the right to health for these people. And also, it would be important to leveling out the argumentation. Bridging the gap between the argumentation on just non-discrimination, on just minimum core obligation, on vulnerability, and making more use of the concept of minimum core obligation in relation to this particular socially and state-made vulnerable groups.
Thank you very much for. Sorry, just because it's a streaming, so I can't people to hear. So thank you very much for 3 very interesting and thought-provoking papers. Okay, I'm not going to use my role as a chair and just open the floor for questions, comments, and we know that all of our paper givers would like to hear them. So please, comments, questions.
Sure. My question relates to your presentation about a possible solution to the migrant crisis. And obviously, we are seeing some unprecedented flows of migrants in the EU. And this puts a lot of pressures to entry points to countries that act as an entry points, and pressure in terms of financial means. So I'm just wondering, yes, it would be great if we could find why immigration flows comes, tackle those problems, and to give migrants the right to return. But at this stage, where the right to return seems like an impossible solution, what would be the right approach to tackle the immigration crisis?
Are there any other questions? Please, I would suggest that we ask 3 questions at once, because so that we have a little more time for discussion. So please,
This is just a little question, and it's kind of mainly my own interpretation. I think it's a little bit of a selfish one. Ben, I'm intrigued by this notion in terms of IDPs between between armed conflicts and generalized violence. I'm just interested to know what the difference is between the two, and just briefly what the law is and how we identify generalized violence.
My question's for Hellen as well. It was just in relation to, and again, perhaps it's selfish indulgence as well on my part, it was in relation to your understanding of cultural identity. And I was just wondering how far you've gone into a definition of that as your research, and how you could gauge that, or how you might suggest that could be gauged in this context.
Okay, I just will give opportunity for all the answer, and I will continue the questions.
So regarding the first question, I think I made it very clear that it's a long-term solution. First of all, I don't intend to put any pressure on Greece, which is the country, for example, you're from, and I think you bring the example because you know more than anyone. But if in a period of time, Greece had the chance of promoting, together with the UNHCR, together with the country of origin, to promote voluntary repatriation, or to keep, along with the burden of processing most of the refugee status requests, what would Greece choose in the long term? It's a question too, so I'll give back the question. But I believe that if Greece had the chance to breathe in a couple of years and engage in the process of voluntary repatriation with international, with the help of international community, UNHCR, and of course the countries of origin of these people, I think it would be a better solution than just to, being responsible according to the Dublin Treaty to process all the refugees' requests. And the second one, very big question. I'm an anthropologist too, it's why I tend to the social science part of it. And I think that the question has to be made to the people that is being repatriated. What do they understand that would be their country of course, they need somehow to prove that the country that they are saying they relate to. Why? Is that it's because the country they were born, they have family there, they've lived 20 years, the majority of their lives there. I know it's very, very hard and subjective, but I think identity should be assessed on that way. Those are my questions.
Thanks. Great question, and actually you've got me thinking about whether I really know the answers to that. Because I'm primarily human rights law as opposed to humanitarian law, but as I think you probably gathered, IDPs straddle the boundary between lots of different areas of law, which is partly one of the big issues in regards to the lack of protection within international law. And going back to your presentation earlier, I think your presentation where you're talking about the minimum level of intensity and the minimum level of organization. I mean, one of the key objective really of the guiding principles is to not exclude anything that would fall below that level, in that the guiding principles were developed in order to hopefully directly respond to the reality of why people are displaced. And if that doesn't reach a certain level of intensity, it doesn't reach a certain level of organization, it doesn't involve the state party directly, then that should mean that those persons are excluded from protections. So it's sort of a lower level of violence and rioting, those sorts of things. And there's something rioting and other things that have human rights implications, I think is important to highlight. But whether there's a minimum level of generalized violence is an interesting question of what level has to be reached for it to be generalized, as opposed to just an individual being affected. Something I don't actually have to speak, so I'll have a look and see what I can find. But yeah, really interesting. I think the way that it would, and partly as a result of the soft nature of internal displacement frameworks, I'd imagine that it would be loosely interpreted. And if an individual was affected, they would fall under human rights violations, even if it didn't fit generalized, and they would still be affected by something. Their human rights would still still be affected in some way, and they fall under the IDP bracket. It's very loose and very good. Thanks.
Okay, I think I'm still going to use my role as a chair and as discussant because I have two questions. But let me first see if there are any other questions from the audience. Yes, please.
One small question for Stefano, of course, yes, maybe because I'm very interested in the not. Did you, of course, you took into consideration the Migrant Committee on Economic and Social Rights, and you mentioned that in the European Council for Economic and Social Rights, they have different definition of vulnerability. But do you envisage also that, like, if you were conducting a study on the European Committee, you would have a different findings, and like the approach to the European Committee is different, is more influenced by European states, and so like also they're just kind of standing on the margin of kind of appreciation that the states can have when and also they like to have to look at the members to be different.
Okay. Any other questions? Hold your hands high so that I can see them. Okay, then I'll really use my role as a chair, and I have two questions. First one is for Hellen. I have a feeling that there's a thin line between the individual right to return and the responsibility to readmit. And I'm referring to the context that I know very well from my research, that's the post-Yugoslav context. So former Yugoslav states, especially the conflict in Kosovo. So where does the right to stay come into play here? For example, most of the people who had temporary protection, status, and even the temporary refugee protection in Germany, who were originally from Kosovo, do not want to return back to Kosovo because they say there's not enough protection and so on. However, on the other hand, we have readmission agreements signed between Germany and Kosovo. So I would like you to comment, when does the right to stay come into play here? Another question is for Ben, also connected to the former Yugoslav situation. When we come to IDPs, there's a very definition. However, the status of the IDPs is often very fluid. It's not really visible whether they're IDPs or refugees. And again, referring here to Roma refugees from Kosovo who were actually seen as IDPs when they were internally displaced within former Yugoslavia. However, then the borders were withdrawn. So, for example, we have Roma refugees in Montenegro from Kosovo, and now we have a border, but at the time there was no recognized border when they actually were internally displaced. So I would really like to hear your comment on situations like this, because UNHCR says they should be classified as refugees. Montenegro still considers them as IDPs. So this is like something what I find very interesting. So yeah, maybe we start with Stefano now. Okay.
Thank you very much for Thank you very much for your question. Yes, I mean, the situation is a bit slightly okay. First of all, we have to consider that the European Committee on Social Rights issued a series of decisions, so a sort of individual state complaint mechanism. In the case of the Committee on Economic, Social and Cultural Rights, that is not possible, but it's the protocol. Something similar can, similar procedure, potentially you can potentially develop. But at the moment, we don't have any particular any particular application at that point. And my findings comes out of the monitoring procedure. But the European Committee on Social Rights issue a series of decisions I told you. So Federation Internationale de l'Homme versus France, Defense of Children International versus Belgium and Netherlands. And in that case, it was particularly important the concept of so-called intersectionality. So undocumented migrants, so that normally fall out of personal scope of the European Social Charter, because the European Social Charter doesn't, in theory, apply to unlawfully present people. But what was important in that case to extend this protection was the fact that these people, I mean, we were talking about children, so a particularly targeted vulnerability, together with irregular status. It would be really interesting to see if this, we have obiter dicta in the decision talking about irregular migrants in general, but still they're just obiter dicta, so they are not precisely targeted towards them. And yes, I don't know if I addressed more or less.
Sorry. You're watching my thinking face.
I'm going to divide the answer into two parts. So it's the right to stay, right, in the country that you became a refugee. Okay. So, well, first, the refugee status is not absolute, so there are some possibilities of ending the refugee status. So in this, if this is the case, then once a refugee will have to go back to its country of origin. And so that would be a case. And the second one is that the voluntary repatriation, in the voluntary repatriation, the refugee has the right to stay, of course, and it's only if he wants to go back to his country of origin, then he could. But I think the right to stay, if you get the refugee status, and if you don't fall in any of the cessation clauses, you absolutely have the right to stay in the country. Does that answer your question?
Thank you very much for the question. I think, not quite sure how I can, if this is a good contribution, but I think that my supervisor keeps telling me to move away from these thoughts, but it's sort of a bigger life's work. But I think the distinction that we have in regards to whether you're an IDP or whether you're a refugee, it's going to become increasingly untenable. I mean, I think that it already experience on the ground shows that it is. I mean, you have different situations around the world, and I would say that formally, if in regards to the former Yugoslav Republic, if someone is now officially recognized as resident in Montenegro, then jurisdiction has changed, and Montenegrin have the responsibility, and those individuals are refugees formally. I guess this context is kind of more clear-cut in some ways than other situations, other similar situations, where really the fluidity or how you're going to be classed, whether you're going to be an IDP or a refugee, is not clear at all. And it depends on your interpretation of internationally recognized state border, what is internationally recognized and what is not. It depends on the individual themselves, I think, and their identity as displaced. So in Georgia, you will have, you will never, well, you very rarely hear anyone refer to themselves as a refugee, because they do not recognize Georgians, that is, they do not recognize the boundary, not border, the boundary, the administrative boundary that exists. And so they will not use the phrase refugee. They also do not feel persecuted by the Georgian state, so they do not see themselves in a refugee situation. But then the issue with that is that you're then not granted the protections. I mean, the UNHCR does protect, but to a certain extent, but Georgia in particular has seen a huge withdrawal of the UNHCR, who have some form of de facto responsibility to protect IDPs. But when that's being passed over to the UNDP, well then UNDP do not have specific categories of people they protect. You then see the unusual opposite in Cyprus, where I've been to recently, and I tried to ask people this question about whether they see themselves as IDPs or refugees, and under Cypriot law, internally displaced persons in international law refers to themselves as Cypriot refugees in domestic law, because refugee is seen to provide an additional status, it seems to suggest that they require international protection. So I think it all comes down to where borders, where boundaries are, whether individuals see themselves as an IDP or a refugee, but ultimately difficult legally is that there are a huge difference in protections, international protections, for individuals, whether they are IDPs or refugees. So I'm not surprised to see the UNHCR say that the Roma in Montenegro are now refugees, and by the UNHCR saying that, at least they fall within their purview of protections. It'd be interesting to speak to the Montenegrin authorities to see how they would justify this situation. But it is difficult when boundaries change. I don't think international law likes it when boundaries change, borders change, and it creates difficulties.
I did speak to the Montenegrin authorities, so very, very interesting. They were still like trying to see that they're IDPs, not refugees, because they didn't cross the border at the time. They were still doing the legislations according to that. But there's still this shit was in there.
Yeah,
I don't want to promote my work now.
Please do. I'm going to do something when I have something.
But okay, I was just saying when I was listening to Ben, this famous saying that sometimes even when people do not cross borders and borders cross them, and we just thought I would like to conclude this panel. And thank you very much all for all your questions, comments, and thank you very much for your very nice presentation. Thank you very much.
I'll just say very quickly, it's not on the program, but it's very hot in here, so I'll have a short 10-15 minute break before we start the roundtable. And then we'll come in and so there should be some cold drinks still out in the social space. So we'll see you back in here in about 10 or 15. Thank you.
Where's your